Good afternoon. I hope that after that break, everybody can stay awake for the last part of this and get ready for the cocktail hour that we'll be hosting later. I'm going to be talking about employment law, and employment law basically takes a look at a vast array of statutes and case law, federal rules and regulations, etc. I'm not looking to cover that vast array today, obviously. I'm going to look at just a couple of the issues that as associations, where some of you have employees, where you might run into some of these employment law issues. Generally speaking, I do business and commercial litigation, and while a lot of that does not include consistent employment law issues, I would tell you that it comes up quite a bit in the context of breach of contract claims, whether that deals with salaries, bonuses, employment contracts, and that kind of thing. And so today, I want to be able to address some of those issues that you're going to come across that are evolving, because employment law is definitely not static. As we move forward in technology issues, you're going to see that the law is evolving, and I think that, you know, as judges change and new generations come in, there's going to be new issues to deal with, particularly with respect to electronic communication and such. And I think George touched on it a little bit with respect to litigation holds and electronic use and how, you know, these are documents and you need to protect them. Well, just like the litigation law has evolved in that respect, employment law is evolving. So today I'm going to address complaints by employees and how they should be handled, best practices for handling those complaints. We are going to also be looking at electronic issues, and we're going to be looking at a couple of the common law claims that arise in the context of employment law. And finally, we're going to briefly touch on employee handbooks. And as you'll see throughout my presentation, the vast majority of my talk is going to be have a policy, write it down, and enforce it. And that's going to be the vein that runs through everything that we're going to talk about this afternoon. So to get started, the typical scenario with respect to complaints is something like you're the HR person, you're sitting in your office having your morning coffee, in walks an employee looking distraught. And he or she says, so-and-so, who's my supervisor, has been calling me honey and darling and sweetheart and has been commenting on my body and these kinds of things, and it's really making me uncomfortable. I'm not able to work here if I'm going to continue to have to work with that person. Now, your first thought as an HR specialist, or if you're just the office manager, whomever is in charge of this, first thing you need to do is look at your policy, your handbook, your employee handbook, if you have one, so that you know what the procedure is for addressing this complaint. Obviously, you want to take it seriously, and you want to make sure that that person who's coming to you with a complaint feels comfortable in discussing the complaint with you and knowing what the procedure is and that that complaint is going to be addressed. And why do you want to do these things? You want to do these things to try to protect your association. You want to make sure that whether it's a frivolous claim or a valid claim, that you are taking some very specific steps in documenting what you are doing to protect that employee. So to that end, you're going to have your complaining employee fill out a complaint report. And for purposes of just having something to look at, you will see that the last page of your materials under Section 6 is an employee complaint form or an employee complaint report. And you all to my right may not have that because it was entered later. But you all in the audience should all have it. And it's a sample form. They're double-sided documents, but the last form should look like this. And at the top of it, it talks about the policy that the company has with respect to harassment. And it reassures your employees that the company is going to take complaints seriously. It has the employee fill out all of the relevant information, his or her name, the department, who the supervisor is, and then goes through a series of questions to try to ferret out what the issues are. One of the main things to remember when you have a complaint reported to you is that you're not going to be all of a sudden investigating people, and it's not like a gossip game. You need to get all the relevant information so that you know how to proceed. So once you have the complaint, then what do? Make sure that it's signed and dated by the person who's making the complaint, and the form that I have for you in particular says that it is under penalty of perjury, because you want to make sure that people take this seriously, that it's not just a he said, she said type of situation where, and everybody has those types of employees. They complain about everything. Well, that's okay. You still need to take the complaint, and you still need to do what is appropriate to ensure that your association is protected. Once you have your complaint, the other step that you need to take, in my scenario, for example, sexual harassment. You need to separate the employees. You need to separate the person making the complaint from the accused. Why? Because what good does it do for an employee to come to you, give you a complaint, tell you what the problem is, and then they have to continue living with that person during the course of employment? That doesn't mean that you go around and you tell everybody, oh my gosh, we're having to remove Susie from the department because Dan has been inappropriate. In fact, that's the last thing you want to do. You want to keep it confidential. You don't even necessarily need to tell any of the other employees why it is that you're removing the person. In fact, I would encourage you to keep it confidential, and you need to assure your employees that your process is as confidential as possible. Don't promise them that nobody will find out, because obviously people will find out, but you want to do the process in an effective, business-like manner. Once you do that, you may or may not have to call your lawyer. And why is that? Because depending on the severity of the issue at hand, your lawyer may need to assist you in getting through the maze of the complaint. The other issue is you need to find an investigator, and people will sometimes use in-house investigators, and employee handbooks often will tell you who the investigator will be. Obviously, you need to be reasonable about it. It can't be the accused best friend who's going to be taking down all the information. You need a neutral person who's going to do a good job of being unbiased and focusing on the complaint and resolving that complaint. One of the things you don't want to do is ask your attorney to serve as your investigator. 99% of the time, you don't want to do that, because if your attorney becomes the investigator and your attorney is the one that's going to be interviewing the complaining employee and the accuser and all of the witnesses, guess what? You've just made your attorney a witness, a potential witness to the lawsuit, because everything that you're preparing as part of this investigation may ultimately need to be turned over. If it's an EOC type complaint, law enforcement issue, they may want to see that file. And so you don't want to put that attorney-client privilege at risk by having your attorney be the one that goes out and interviews everybody to find out what occurred. So what should be in your investigation? Once you've set out your investigator, you should map out your plan on how you're going to conduct the investigation. Obviously, you're going to want to do interviews. You're going to want to get witness statements. Make sure that those witness statements are also signed and dated. And you want to put all this information in your investigation file. In the event that this complaint moves on from just being an employee dispute to becoming perhaps an EOC complaint, again, you can show that you were proactive, you took charge, you took the necessary steps to try to resolve the issue. Other things that you can look at, and this is also part of your notes, you might want to look at personnel files. You want to look to see if something like this has happened before. Is this a pattern by the accuser, or is it a pattern by the accused? You're going to look at performance evaluations, all of these things that will give you an insight as to what is going on. Some of the forms that you want to use in order to document your investigation, obviously you're going to have the complaint, you're going to have your notes, the investigator's notes. The investigator's notes should be clear, they should be objective, and concise. There's no need to have long, drawn-out narratives about who the bad person is and the good person is. It's facts. Who did what, when, and where. That's what you want to focus on. Again, and I think Jennifer was the one who said this in her presentation, is this something that I would mind being read out loud in court? You know, so if your investigator's sitting there commenting on unnecessary things, why are you cluttering up your file? Make it professional, businesslike, focus on the issues. Of course, you do want to make sure that you give the accused an opportunity to respond to the accusations that are being made. And finally, once you have your investigation completed, you're going to want to have a report and a determination as to what should be done as a result. Reports can be oral or written, but you do want to keep in mind that there are pros and cons to each. If you have a written report, again, it could be used in court at a later date. So you want to make sure that if you're going to have a written report, that it is, again, concise and to the point, objective, showing no bias. Once you make a determination as to what you're going to do, if you are going to discipline the person that was accused, you want to make sure that you tell that employee why it is that the disciplinary action is taking place, and you want to give them the substance of the report that led to you making that decision. All of this should be put together. You should have it as part of the employee's files, and in the event that you're ever questioned about what your procedures are, there's not going to be a question that you were following clearly set out procedure. So of course, again, in your employee handbook, that's the perfect place to put it in. You let your employees know right up front, we have a policy against harassment, whether all of it, sexual harassment, racial discrimination, etc. And not only do we have a policy, but we have a process in place about how the complaints are gonna be resolved, and this is what we do, or the consequences of breaching that policy. So with that in mind, I just want to extort all of you, please be brief, factual, and objective in your reports. The next issue that we have is going to be employees with respect to electronic devices. And as every year goes forward, obviously, so does technology. In fact, if you buy a phone today, it could be outdated tomorrow. And we all know that technology is quickly changing. So with that, we also need, as employers, we also need to change, and we need to make sure that we're addressing those issues. Some of the big issues that are arising with respect to the use of electronics are security issues, is being the first one. Whether it is an employee who leaves the employment and takes with him or her confidential information, whether it's the employee who is surfing the web and unwittingly allows a virus to enter into your server, whether your employee is utilizing employer resources to conduct separate business or excessive amount of personal information and personal communications. You need to keep all of these in mind with respect to the security of your systems. So again, what do you do in this respect? You need to address it in a policy. You need to address situations in the event phones or laptops are lost. And for example, if you have confidential information, they should be password protected. They should have strong password protection. If you're allowing your employees to take devices outside of the office, they should be protected, because if that employee loses that laptop and somebody can just go in and view all of your information relating to how you run your business, how you conduct your business overall, obviously you are giving your competitors and you are giving strangers very valuable information about your business that shouldn't be out there. So you should address that. You should also, for purposes of preventing computers from being susceptible to viruses, you should not allow employees to upload or install software or hardware onto their computers. The only software or hardware that should be on those computers are those that are approved by and or installed by your IT department. In your policy, you should also address the fact that once an employee leaves employment with your association, that they need to return everything. They need to return electronic records. They need to return, if the mobile device was provided by the association, that needs to be returned. Laptops need to be returned. You know, in the old days, when we didn't have laptops and phones, it was absolutely required in employee handbooks that you would have a phrase in there. All documents must be returned at the end of employment. Well, now we're not just talking about paper documents. We are talking about electronic devices that have the capacity to store information and to have that information basically taken from your association, perhaps to another association, or the valuable information that is transmitted to third parties that shouldn't have that information. Email retention policy. This was touched upon before. As part of your policy, you should also address that issue, and that is if you keep your company records, and actually this is an issue that has curiously come up in a case that we're involved in right now, and that is that there's a bank involved, and it is their custom to delete all non-substantive emails every 90 days or so. Well, what constitutes substantive matters? In this particular case, we're arguing that they've gone ahead and they've deleted all sorts of emails that they should have kept. And now the question is, where do we get those documents? That's no worse than taking contracts and correspondence that's on a piece of paper and putting them through the shredder. In litigation, the other side has a right to look at these documents. And while you may have an email retention policy that says you can get rid of them every 90 days, if your policy says that substantive emails need to be kept, then you need to make sure that you train your people on what substantive emails means. And you need to make sure that things aren't routinely deleted. Because some people will just have a mechanism, some of the businesses will just have a mechanism that every 90 days or so, it's automatically gone. And if you don't have backup tapes, you're going to create a very serious issue down the road when or if you get involved in litigation. And a curious thing that isn't often paid attention to, but that was brought to my attention at a recent seminar, was the fact that some copy machines, some fax machines, they have the capability of storing everything that you have photocopied. And you need to look into that, because that's another issue that I think as time goes on, everybody's going to clue into. And again, just like everybody expects you to save emails, now they're going to ask you, well, what, photocopies, what does your photocopy machine have in it? Are there documents stored in there that you haven't produced to us? So you need to make sure that you address all of these issues. They're ever evolving, and you're not going to get a single response as to how to deal with these issues, but there are issues that need to be at the forefront that you should be considering. There is an Electronic Communication Privacy Act that was passed in 1986. Curiously enough, it was, I think, the intent to protect employees' privacy. What has happened, I think, with the cases that have come down recently at the federal level is that employees do not, in fact, enjoy privacy at the workplace with respect to electronic communications. And one of the issues is attorney-client privileged information. Generally speaking, you have the privilege of speaking with or writing to your attorney, and that communication is protected. However, be warned, if you are conducting that communication over your employer's computer system, through your employer's email, whether it's Outlook or whatever it is, you may have lost that privilege. And people, perhaps on the other side of the litigation will have access to that information. And there are two cases that we're going to get into now that we're going to talk about common law employment claims. One of them is an often used claim by employees against employers, and that is invasion of privacy. And the definition of invasion of privacy is there in your documents, but basically it's an intrusion that is a wrongful intrusion into one's private activities in such a manner as to outrage or cause mental suffering, shame, or humiliation to a person of ordinary sensibilities. This involves physically or electronically intruding into one's private quarters, or, stated differently, trespassing or intruding on or invading one's physical solitude or seclusion, as by invading his or her home or other quarters. That's a lot of legalese to basically say that you shouldn't be digging through people's personal private information where they have an expectation of privacy. And so the hardest part of that invasion of privacy, even though it is one of the claims that's most often brought by employees in the employer-employee relationship, is that they have two big hurdles to cross, and that is that it has to be highly offensive to the ordinary person. And so when the courts look at that, a lot of times they go, is it really that offensive that an employer who is paying you to work, who is giving you a computer, who is giving you company resources to conduct company work, is it really that objectionable that that employer may monitor your activities from time to time? And most courts have said no, but most courts have said no where there's a stated policy in place. And again, that's the key. You need to have a policy in place that expressly tells the employees that they are subject to monitoring, that they are not to use the email provided by the employer for purposes of conducting private activities. Now, you need to be reasonable as an employer, okay? If Susie is writing to her daughter, honey, I'll be home at 5 o'clock, should you be monitoring those types? No, you shouldn't. And I think employers would make a big mistake if they make employees feel like they're constantly being spied on, okay? Conversely, employees, I think, need to be cognizant of the fact that the laws don't really protect them. And they need to be careful and selective about how they're conducting their personal activities during business hours. There are two cases that I cite in the materials. One of them is the case of Gina Holmes, and the other is the case of Maria Stengart. And in the case of Gina Holmes, Gina had engaged in a lawsuit where she accused her employer of a number of salacious and sundry things like sexual harassment, et cetera, et cetera. The attorneys on the employer's side were able to obtain attorney-client communication that Gina had engaged in by using the employer's computer, okay? And in that case, the court held that the attorney-client communications over work computers were not privileged because she had been warned that the account was to be used for business purposes only and the emails were not private, and that the company would randomly and periodically monitor its technology, okay? So all of those things were told to her. They were in a handbook. She signed the handbook. She acknowledged that she knew that those were the policies, and nevertheless, she engaged in these privileged communications with her attorney over the computer, and the court said, I'm sorry. It's not going to be protected. On the other side, we've got the case of Maria Stengart. And in that case, it's a New Jersey Supreme Court case. And in that case, Maria Stengart had been engaging in communications on her employer's computer, but through the use of her Yahoo email account. And there's a lot of issues in that case regarding what the lawyers did or shouldn't have done that I think also made the court wary about the fact that the employer was looking at these emails. But one of the key differences in the Stengart case was that while there was a policy, it really wasn't that definitive. And it didn't talk about the use of your private email address for purposes of private activities. So there is a way to harmonize those cases. And the way to do that is that in the Stengart case, you've got an employee's personal internet-based and password-protected email account. Yes, she was using the employer's computer, but she was not using the employer's email account. In contrast, you've got Holmes, where she was using the computer. There was a very solid policy in place, and she was nevertheless engaging in these activities. Takeaway from that, yes, you want to have the policy. You also don't want to be overzealous in monitoring your employees, particularly where you know that they are private conversations. If there's an inkling that you may have an issue because it's attorney-client communications, call your attorney before you go and read all of those documents, because you don't want to be guilty of breaching that privilege, even if you think, no, but I've got a case. I'm okay if I read these communications. It's better to be safe than sorry. If you think that they are private, privileged communications, you should call your attorney and get legal advice as to what to do with them. So that's the first common law claim that I wanted to discuss. The next two are tied together. That's negligent hiring and negligent retention. And basically, that's where you know that an employee shouldn't have been hired, or you didn't do the correct amount of background work and that employee was hired and then caused a third-party harm. You're required to do an appropriate investigation. One such investigation would include, hey, if I'm having somebody drive a truck for my company, I should probably do a driving background check. You don't want somebody who's got 5 DUIs in their background, whether it's in another state or here, driving a truck for you, because you're going to be subject to vicarious liability. The difference between negligent retention and supervision and negligent hiring on the one hand and negligent retention on the other hand is just, when did the employer know, or when should the employer have known that there was a problem with that employee? And if they knew that there was a problem, why is that employee still here? And if that employee is still here and causes harm to a third party, you as the employer are going to be liable. The last two issues are fraud in the inducement, breach of contract. Basically, as an association, if you're hiring employees, you don't want to tell them that you're going to give them the moon and the stars so that they come and work for you and then pull the rug from under their feet and not give them what you promised. If you induce somebody into coming into your employ, and they relied on the representations that you made to come work for you, and then you don't do what you said you were going to do, you're going to be subject to liability. The breach of contract issue, similar. The claims that usually come up as breach of contract, like I said before, bonuses, salaries, non-competes are a big one, and frankly, that's the ones that I think we most deal with, or that I deal with. I've seen a lot of non-competes, whether it's from the employer or the employee. So in closing, because I think I've run out of time, tips for developing and updating your handbooks. Clear and conspicuous disclaimer that the handbook does not create an employment contract. Make that very clear up front, because most of your employees will be at will, and you don't want to make them into not being at will by virtue of your handbook. Have clear and concise language. Don't use legalese. Make sure people understand what you're asking them to comply with. Address all of your policies, rules, and regulations. Explain your complaint and concern procedure. List what your benefits are, including vacation and sick leave. Obtain signed acknowledgments. And last but not least, the fact that you have a handbook today doesn't mean it'll work for you 5 years from now. Get it updated. At our firm, we do handbooks for a large number of our clients, and I think that it serves them well.